Hi, this is Lisa Sloan. We're the Technical Assistance Collaborative. Thanks for joining this afternoon. I think it's some of you, if anybody's on from the West Coast, it might still be morning. But we're really excited today to be doing part one of a two-part series on reasonable accommodations. Today will be more of an overview of fair housing law and reasonable accommodation, and part two, and we'll give you the date a little bit later in the slides, will be focused on some of the situations many of you are finding you're having to deal with and the reasons you joined the call. So we're really pleased to be able to collaborate with Debbie Pilch today, who's going to present today's webinar and the next webinar and be here to answer your questions. Debbie is an attorney. She really, she's kind of the perfect person for us to be doing this. She's a national expert, in fair housing law and reasonable accommodation. She has worked both on the kind of disability side with a legal services organization, but also on the housing compliance side with a large property management company. So she understands these issues from both perspectives and understands the law in this area. I think you'll find her to be very, very helpful. Before we get started, I just want to go over a few housekeeping items. One, all the participant lines are muted. If there's time today, we'll do a Q&A session at the end of the webinar. There are a lot of people on this call, so we really need you to put your questions in the question box as you think of them during the webinar. Or at the end, when we have the Q&A session, you can hit the little raise your hand button. You can click on that, and we'll unmute your line. If we don't get to your question today, we will on the next webinar. If you'd like to print out the slides for note-taking, I believe if they're not here now, I'm not sure if they're up there for downloading right now. We'll see if we can do that, and if not, we'll send them to you, all the people who registered at the end. This webinar is being recorded and will be posted on HUD Exchange as soon as we do all the technical things that have to do to make that happen. So if you want to see it again or have one of your friends or colleagues see it, it will be available for that. So without any further ado, Debbie Pilch.
Hi, everybody. I apologize for the technical difficulties. I think anybody who's ever tried to utilize the webinar software or do anything technologically, you can appreciate how stressful it is. But again, my apologies. I just want to go over today's agenda. First of all, we're going to begin with the legal obligation of grantees and housing providers of the Project Rental Assistance Program to provide reasonable accommodation to both applicants and residents with disabilities. Once we do that, we're then going to go over when an accommodation is considered reasonable versus unreasonable. Lots of times when I train, housing providers in particular want to know, well, when can I reject an accommodation? Although I like to focus on the importance of an interactive dialogue and meeting the needs of people with disabilities, it's important to understand and be aware of the limitations of providing an accommodation, and we're going to spend time on that. The other area we're going to spend time on is around verifications. What's permitted, what's not permitted, what's a good strategy, what are good business practices when you're not getting things returned. We're also going to get into some examples of reasonable accommodation, those that are commonplace in not only the context of applying for housing, but throughout the occupancy cycle. We're also going to talk about common concerns that are raised by people in the industry, and by industry I mean the housing industry. And generally speaking, there are four that I'm going to cover during the training, and again on the second part of the reasonable accommodations training, I'm going to go over them again. And finally, as Lisa said, if we have time, I'm going to take questions. Please know that if you don't get your questions answered today, I strongly encourage you to send in your questions, and I'll make sure to the best of my ability that I cover it in the next training that we do, which is really going to focus on some of the more complicated issues. But before we begin, I really need to emphasize the importance of being present today. I think it's easy on a webinar in particular to zone out and or multitask at your desks or be distracted, because I know for me I've got 1,000,001 things to do, and I'm sure everybody on this call feels the same way. But to the degree possible, put your phones away, focus on what we're doing, and try not to be answering emails at the same time. I also want to say that although, as Lisa said, I am an attorney by training, I am not giving you legal advice today. I am not your lawyer. I'm not tax lawyer. I'm nobody's attorney, and it's important for you to realize that. We strongly encourage you that if you have individualized situations going on, to please consult an expert in not only reasonable accommodation, but landlord-tenant law that is state-specific, as well as knowledgeable about the federal law. I also want to mention that it's important for you to rely on your agency or company's internal fair housing expertise and their resources, as well as HUD's resources. HUD has a number of extremely well-written resources out there, and I'd encourage you to seek them out. And then finally, again, ask questions. I can't promise that I'll have time to answer them all today, and I also find it helpful if there are complicated areas to really be able to flush them out. So that being said, I want to now begin with why grantees and owners and agents have to understand reasonable accommodations. Basically, any grantee or owner or agent involved in the 811 PRA program is required to comply with federal and state laws which prohibit discrimination against people with disabilities, as well as other protected groups. The purpose of this training is to really focus on persons with disabilities and the obligation to provide reasonable accommodation. In no way are we minimizing the importance of complying with laws that protect the vast number of groups covered by federal and state fair housing laws. And these include the Fair Housing Act, which prohibits discrimination based on race, color, religion, sex, national origin, familial status, as well as disability. So we want to emphasize, again, the Fair Housing Act prohibits discrimination on the basis of a number of other groups, but today we're focusing on disability. And in addition to the Fair Housing Act, which prohibits discrimination on the basis of disability, we have Section 504 of the Rehabilitation Act, as well as the Americans with Disabilities Act, as well as, of course, your state law, and we don't want to minimize that. It's important for everybody to understand reasonable accommodation in the context of discrimination law, because the refusal to make reasonable changes in rules, policies, practices, or services, or provide a physical change to a unit or the common area when the accommodations are necessary to afford a person with a disability the equal opportunity to enjoy or use a dwelling is a form of illegal discrimination. So you cannot separate out your obligation to provide an accommodation from your obligation to comply with fair housing laws. And that's important for you to understand. So the next question that comes up is, well, then what's the definition of a person with a disability for the purposes of civil rights law? And I'm emphasizing that what we're discussing at this moment is for the purpose of civil rights law. So the law, and when I say the law, federal laws and many state laws, because they oftentimes mirror the federal law, has a three-pronged definition. The first prong is the person has a physical or mental impairment that substantially limits, which means limits a lot, a major life activity. So this raises the question, well, what do we mean by a physical or a mental impairment? So I want to discuss that for a minute. And I'm effectively taking this definition directly from HUD guidance, which we've provided you towards the end of the slides. But it's a broad term. It's a physical or mental impairment includes, and I want to emphasize, it's not limited to, but includes, which means there are other types of physical or mental impairments that would be included, such diseases and conditions as orthopedic, visual, speech, hearing impairments, cerebral palsy, autism, epilepsy, muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes, HIV infection, mental retardation, and that is an old term that is used, and oftentimes it's still used within the law. However, ideologically or politically, it is a less acceptable term. Oftentimes it would be intellectual disabilities or cognitive disabilities, as well as emotional illness, alcoholism, and drug addiction versus current use, okay? The current illegal use of a controlled substance does not constitute a disability for civil rights purposes in and of itself. Then we get into the second prong. So the first prong of having a physical or mental impairment that limits a lot a major life activity. So we've covered the physical or mental impairment, but then we get into, well, what is, again, substantially limits? It means significant or to a large degree. And then finally, what about major life activities? Well, basically, it's what you do in your daily life. It's includes things that are of central importance to your daily life. It could be seeing, hearing, walking, breathing, performing manual tasks, caring for oneself. So in other words, the ADLs, learning, speaking, etc. Again, in each context, when we're talking about physical or mental impairments or major life activities, these are examples that I'm providing you. The concepts are not to be all-inclusive. So as I said, the first prong of this three-pronged definition is a physical or mental impairment that substantially limits one or more major life activities. The second prong is someone who has a record of an impairment. I have a history. I no longer have the disability, but someone acts on the basis of a history. So for example, in the state that I live in, which is Massachusetts, one of the preeminent hospitals for treating people with mental impairments is McLean Hospital. They have residential programs there, treatment programs where people can live for a lengthy time frame. And, excuse me, and if I had historically lived in one of those treatment programs and I listed it with an address that a housing provider recognized, and that housing provider thought to themselves, I don't want to rent to somebody who has lived at McLean Hospital, therefore I'm rejecting them. Excuse me, whether I have the disability now or not, if someone is basing it on a history, and we're not talking about any behavior related to the history of the disability, but simply the history, that would in and of itself be illegal. The third prong has to do with what people think, their assumptions. So a person who's regarded as having an impairment. So when I started many, many years ago working representing low-income people in discrimination cases, it was not unusual, it was during the height of the AIDS epidemic, and it wasn't unusual for people to have lesions on their face or their arms or their legs and go into a housing office, and the housing provider to not only say but literally send a letter saying, I'm rejecting you from housing because I believe you to have AIDS. That's what we call a smoking gun. It's irrelevant whether the person actually has AIDS. What's important is that the housing provider or the agency rejected the person on the basis of what they assumed. Okay, so again, three prongs, I only have to meet one of them. Now, what's important to realize is, again, I can't say this enough, this is the civil rights definition. It's a very broad definition. It is not the same as any definition of disability for Social Security, and it's not the same as the eligibility definition of a person with a disability to get into the 811 PRA program or any public or assisted housing program, or to be eligible for allowances against income. What's important for you to realize is that I could qualify, I could meet the civil rights definition, and you would need to provide an accommodation during the application process, and I may not be eligible as a person with a disability for your program. So again, you're not going to know that until I apply and go through the process, but you still have to provide the accommodation regardless of whether I'm eligible as a person with a disability for your program if I meet the civil rights definition of disability. Okay, so now that we've covered the definition of disability and discussed how broad the concept is, and by the way, if we're all fortunate enough to live long enough, we are likely to acquire a disability as we age. And that's important to keep in mind because a lot of people's disabilities are hidden. We don't see them necessarily, and most people acquire them because as we age, our cognitive abilities may change as well as our mobility capacities. So it's important as people age in place in your housing as well, you're likely to also see an increase in not only requests for reasonable accommodations, but in varying types of accommodation requests. So let's get into what is a reasonable accommodation. Although the concept of an accommodation or modification is central to federal and state laws that prohibit discrimination against people with disabilities, it's important to recognize that different laws use different terminology. And so what we wanted to do is give you a couple of examples. So the Fair Housing Act, which applies to all sites, so we're talking about market sites as well, even those who are not obviously covered by the 811 program, but we're talking about a straight market site, are likely to be covered by the Fair Housing Act. There are very few exceptions. That law uses two terms, reasonable accommodation to describe rules and policies and procedures and services, where they use a second term, physical modifications, to describe physical changes to a unit or the common area. In contrast, Section 504, which applies only to sites that receive federal dollars, such as your sites, which is funding through the 811 PRA program, use one term, reasonable accommodation, to describe both. So because everybody on this call is covered by 504, we're going to use for the purposes of today's webinar the concept of reasonable accommodation in accordance with 504, which includes not only rules, policies, procedures, services, but physical modifications as well. Because again, grantees and owners and agents must comply with not only the Fair Housing Act, but 504 as well. Okay, so what is also helpful is to understand the context in which you have to apply reasonable accommodation. And one of the things we wanted to emphasize is that the obligation applies throughout the occupancy cycle. Okay, so that's going to be not only your application and research process, which includes alternative formats and putting things in plain language and excuse me, how and where an interview is conducted, but negative tenancy history as well as criminal history and considerations of mitigating circumstances as a form of an accommodation. It also impacts waiting list update as well as physical modifications. And there are what I would call typical ones, and those include the grab bars, garage door openers, handheld showers, raised toilet seats, automatic door openers, and carpet removal. The most common, at least from my experience as a housing provider, are the grab bars and the raised toilet seats, especially as people age in place. Okay, so then we've also got your services and your activities, the programs and the activities that you offer at the site to be able to be inclusive, not only the transportation services that you provide, but where you're holding them. Are they accessible? In addition, assistance animals, live-in aids, we've got internal transfers, which I would like to remind everybody that in accordance with HUD guidance, we pay for internal transfers that are a result of a reasonable accommodation. And then finally, lease violations and eviction. Now, we recognize that some of the topics are more complicated than others, and we're going to focus on specific topics in the second webinar. We're going to focus on negative tenancy history, particularly criminal history and the consideration of mitigating circumstances as a form of a reasonable accommodation. We're also going to focus on the physical modifications to some degree, and services and activities. We'll focus on assistance animals, and we're going to also focus on live-in aids. And then finally, we'll be focusing on lease violations and evictions. Okay, so I want to talk now about the limits of an owner's obligation to provide a reasonable accommodation. And when I say owner, I am including grantees as well. I don't want you to feel left out. So it's both the grantee and the owner. You don't have to take any action that is going to fundamentally alter the nature of your program or pose an undue financial and administrative burden. It's not or, it's and. So you might be sitting there saying, well, what does that mean? Okay, what is a fundamental change, and what does undue financial and administrative burden mean? So let's start with a fundamental change. A fundamental change is a basic change in the nature of the housing program. You are obligated, so the nature of your housing program is to provide decent, safe, and sanitary housing to households who are at or below a specific income limit, who meet specific eligibility requirements, including a household member having a disability that meets the definition of the 811 PRA program. Okay, so that's the fundamental component of your program. So therefore, to determine if an accommodation is going to result in a fundamental alteration requires you to determine the primary purpose of your program, which we just mentioned, and the components necessary to achieve it. It's not a cost-based analysis. This is a what's the purpose of my program and how do I do it? So a starting point is obviously looking at your lease. So what does the lease require? Would an accommodation in any way violate that lease? That's really what you're going to start to think about, and even in terms of your tenant selection plan, which we'll talk about extensively next time when we talk about tenant screening, but I want you to keep it in the back of your mind. So that what I also want you to realize is that if an accommodation request would require either a grantee or an owner or agent to provide a service that's not part of the site's housing program, it can be denied. So let me give you an example. Oftentimes, assistance animals are a big issue at the site. So, and we're going to talk about next time, why that is and what a housing provider can and can't do in regards to assistance animals. But right now I want to focus on a common scenario, which is a resident stopping a maintenance provider and asking the individual to please walk the assistance animal for the resident because they can't do it themselves. That's an example of a fundamental change. We don't walk dogs, period. And nor is it a good business practice for maintenance providers or any other staff person to go out of their way to meet a resident's need in this, because then it no longer becomes a fundamental change. It becomes part of their job description. And so it's really important for people to understand what is required and what isn't required. It's a fundamental change to walk someone's assistance animal. It's not a fundamental change for a resident service coordinator to assist a resident in obtaining services from a third party and the resident paying for it. So I want you to think about it in that context. Okay, so what we also had was, somehow this got out of order, but that's okay. What we have here is a chart that summarizes the various laws and the type of change under 504 in the Fair Housing Act and who pays. And I'm going to go over this now because I think it's important when we talk about undue financial and administrative burden for people to understand the differences in the laws and why when we mention undue financial and administrative burden, the grantee / owner is paying. So as you can see in this chart, that it's under the Fair Housing Act, if you were only covered by the Fair Housing Act, that you would not be obligated to pay for a physical modification. You could require the resident to pay. However, because you are covered by Section 504, the owner pays up to the limits that are going to be discussed in a minute. Okay? So it's important to know that most accommodations relating to rules and policies and procedures don't cost money. They really are going to focus on the fundamental change piece, and that costs are standardly associated with the physical modifications. Although what's important to note is just statistically, most accommodations, as we mentioned, the toilet seats, the grab bars, do not cost very much money. So with that in mind, what I want to do is I want to look at the concept of undue financial and administrative burden and how it's determined. So whether an accommodation is going to pose an undue financial and administrative burden has to be determined on a request by request basis. So why is that? Well, it's because every grantee's or property's administrative and financial capacity is different, and it's not static. It changes all the time during a fiscal year. Also, your short-term and long-term capital needs plans, if you are an owner, are going to vary. Whether a site needs a lot of work is going to vary. Is your roof about to cave in? Is the boiler about to go? Again, individualized. Also, your administrative staff is individualized. Some of you barely have enough staff, or you don't have enough staff to get the basics done, let alone anything else. So this obligation of providing an accommodation in relation to undue financial and administrative burden, so the standard is met or satisfied when an entity wouldn't be able to operate in a way that meets its legal and contractual obligations. But what I want to remind you of is what we just discussed a minute ago, which is that most accommodations are not costly, even physical modifications. The number of rolling showers, ramps, major changing out of door openings where you have to remove some walls. I'm not talking about a load-bearing wall, which you would never be required to do, is few and far between relative to the grab bars, the toilet seats, the lowering of cabinets, etc. So I want to make sure everybody's aware, though, that the obligation doesn't end if the initial request is determined to be unreasonable. And I want to say something about determining that an initial request is unreasonable, okay? Because if you're going to argue or say or deny a request because it poses an undue financial and administrative burden, you need to document this. You need to have done a cost analysis of the reasonable accommodation. You would have to have sent out requests for estimates of doing the work. You would have to have compared that to your budget, looked elsewhere for the resources. So for example, going back to an asset manager and saying, is there money in reserves that I can use? What else might be available? So that I want everybody to realize that if you have done all that and you've still concluded that it either poses an undue financial and administrative burden or a fundamental change, you're required, whether you're the grantee or the owner, to engage in an interactive dialogue with the applicant or the resident to determine what will meet their disability-related need but not pose a fundamental change or an undue financial and administrative burden to the property. Failure to do so is a denial. And it's okay to deny something if you can't reach resolution. If you can't do something that is going to satisfy the needs of the person with the disability, unless you were to fundamentally alter the nature of your program, or it would result in an undue financial and administrative burden. And again, I want to remind everybody that in the case of an undue financial and administrative burden, you would need to explore if and when the work or a portion of the work can be done, and the person with the disability always retains the right to pay for the requested accommodation or up to the portion that makes it not an undue financial and administrative burden. Because remember, we are also covered by the Federal Fair Housing Act. Okay, so now that we've covered fundamental change and undue financial and administrative burden, I want to emphasize the importance of you knowing your program or your site's policy. And when I say policy, I'm talking about a reasonable accommodation policy. And this would include how a request is made, the process for determining if an accommodation is provided, any of the applicable forms and documentation procedures, who, if the grantee or this site, is responsible for compliance with Section 504, as well as documentation. It's really crucial that people be trained in your policies and your procedures, and all staff, including maintenance staff, because the maintenance staff, and I'm talking to the owners here, agents, have the most contact with residents, generally speaking. It is crucial that they be trained in what your procedures are and how to identify whether or not someone is making a request for an accommodation, because we are now going to talk about how someone gets an accommodation, and it's important that all staff particularly be trained in identifying when someone is making a request and erring on the side of that a request was made when reporting it. Okay, so someone must make a request in order to get it. It doesn't have to be the individual, it could be someone on their behalf, and I'm going to come back to that in a minute. The words reasonable accommodation are not required. The standard is whether or not a reasonable person would know or understand a request is being made. So if I said to a maintenance staff person, oh, I'm having some difficulty in the shower, I'm afraid I'm going to fall, I could really use a grab bar. I didn't use the words reasonable accommodation, but a reasonable person would know that that's what I'm requesting. Okay, so if a reasonable person would know, then yeah, a request has been made. We are on notice. And so here I gave you a couple of examples in the slide, and I want to emphasize this. A request can be made to any employee of the site or the grantee. It doesn't have to be the manager. You are considered on notice. So if a resident makes a request, you have to take action. Again, you're on notice regardless of the employee's position. Okay, so does the person making the request have to be the person? No. As I indicated a minute ago, it can be someone acting on the resident's behalf. So it could be a child or a parent. It could be a healthcare provider. It could be a friend. Okay? And this is not to be all-inclusive. I'm trying to give you examples of who it could be. It could be anyone who's acting on your applicant or your resident's behalf. Now, things can get a little tricky because sometimes at sites, I'll say children or parents think they know what's best for the other. And sometimes the resident, we'll assume it's, a resident, doesn't want what the child tells you they want. And so one of the things we wanted to make sure everybody is aware of is that unless the applicant / resident is a minor or under guardianship, you need to confirm with the person that they want the requested accommodation. Also, you may need to obtain a release of information from the individual if you need to obtain third-party documentation. We're going to talk about the circumstances under which you don't need third-party verification, but if you do, you're going to need to obtain it from the individual on whose behalf it is being requested, unless the individual requesting it is has power of attorney or is a guardian of the individual. Okay, so I want to move on to whether or not you can require someone to fill out your agency's or site's reasonable accommodation form. The answer is no. You can encourage them to do it, but you cannot require it. And I know that this can seem like, well, why? And it's because this is what the law says, and the reality is that we have to follow, whether we agree or not, the procedures that HUD has stated. Now, I certainly can understand why a housing provider or a grantee would want written documentation of a request. And one of the things I want to emphasize is that if someone doesn't want to fill out a form, raising your voice and telling them they have to isn't going to help the situation. We've all been in situations where we have the opportunity to either escalate it or not. And so what I'm going to encourage you to do is to, first of all, explain that the purpose in having the request in writing is to avoid misunderstandings and ensure that you're meeting the individual's needs. So I think when we explain things to people in that format, it helps. It helps to ease, well, why do I need to put something in writing? It's also important to offer to help them fill it out or do it for them and have them initial it for accuracy. Forms can be overwhelming for people under so many circumstances. Excuse me. And I want to remind people that not everybody reads. And certainly not everybody reads English. And, it's important for us to remind everybody of the obligation to meet the needs of individuals whose primary language isn't English and who have a limited ability to read, write, and or understand English, the acronym for which are people with LEP, and our obligation to provide meaningful access. But it's just important to be kind when trying to work with someone about filling these things out. And if someone still refuses to fill out the form, send a letter confirming your understanding of the request. Now, I want to make it clear that the person still has to sign a release form for you to be able to verify that the person has a disability and or the nexus between the disability and the need for the accommodation if it's not obvious, even if the person refuses to fill out the request form. Okay, so it's what I want to make sure everybody understands is that if you need that third party and they're refusing to fill out the third party, again, you want to be documenting that as well. And say, hey, I'm happy to process this whenever you're willing to fill out the release form or provide me a third party on your own, documenting it. Again, we approach it with kindness. All right, so let's talk about the process used for determining if a person's request is granted. It's a standard process. It doesn't matter what the request is. The first is, does the person have a disability that meets the civil rights definition? And we went over that. Do they have a physical or mental impairment that substantially limits a major life activity? We only get into the history of it when someone's negative tendency related history or background occurred prior to current times and the person had a disability then and no longer has it. Otherwise, we really don't get into the issues of history or being perceived at when we're talking about reasonable accommodation. Okay, does the person need the accommodation because of the disability? Is there a nexus? So in other words, Johnny has ADD and Johnny wants a dog. Does Johnny need the dog because of the ADD? That's the difference. It's not that just because someone has a disability, they get an accommodation. It's do they need the accommodation in order to have an equal opportunity to apply to and or live in housing or enjoy services connected to housing? Does the accommodation pose an undue financial and a fundamental change in the program or an undue financial and administrative burden? Information gathered is limited to these inquiries. That's it. So we focus on these things. So the first one I want to turn to is a person's disability. Okay, so if the person's disability is readily apparent, obvious, or otherwise known, can I verify it? Big fat no. Okay, now again, I may not like the guidance that HUD has given because I don't like the concept of obvious or otherwise known because it may require me to make assumptions. But the guidance says that. And there are specific examples that HUD has provided, and I think it's important for us to get a sense of what HUD is talking about. So examples that someone has a disability that satisfies the civil rights definition that are obvious include an applicant who uses a guide dog, a resident who uses a wheelchair, a motorized scooter or a cane, and an applicant who communicates with you using a sign language interpreter. HUD would say all of these are obvious. Why would you bother to verify that the person has a disability that meets the civil rights definition? And in fact, if you do it, you're violating the law. Likewise, if the nexus between the person's disability and the requested accommodation is readily apparent, obvious, or otherwise known, can it be verified? Again, big fat no. So what are some of the examples or the types of examples that HUD has provided? Well, first of all, a resident who uses a wheelchair requests that management assign her a parking space close to the building. There's a clear nexus between someone with a mobility impairment who needs a parking space close to the building. Or an applicant who has a guide dog requests assistance in reading and completing an application. Again, logical, obvious in that somebody with a visual impairment that requires a guide dog would need assistance in reading and completing an application if they requested it. All right, so let's turn to how readily apparent and otherwise known is really defined. So first of all, HUD's guidance uses readily apparent and obvious interchangeably, and it suggests that readily apparent is whether, again, going back to that reasonable person standard, whether that person would find it so. Otherwise known includes someone receiving disability benefits. So in other words, there's case law in which a housing provider said, well, in was relation to a reasonable accommodation, well, we had no way of knowing that this individual had a disability. And courts have said, well, what do you mean? When your resident has been your resident for umpteen years and they're under the age of 62 and you've been giving them the medical deductions on rent calculations and they're receiving disability benefits, it's really hard for us to accept that you didn't otherwise know that this person had a disability. So I think it's important to think about what is reasonable? Would I otherwise know this information? It can also include third-party verifications provided to the grantee or an owner or agent, such as a letter from a healthcare provider or a social worker. And I want to emphasize that third-party verification doesn't have to be from a medical provider, a doctor. It could be from a caseworker. The key is whether the documentation establishes whether the person has a disability and whether the person needs the accommodation as a result of the disability. Again, the nexus. Okay? So if you receive a letter from a healthcare provider that says, my patient who I've been treating for 10 years has a serious case of asthma and they absolutely need their carpet removed as a result because it interferes with their breathing, the nexus is established. The disability is established. You don't ask a resident to then fill out a third-party verification form because you've already got your answers. Okay, so let's go on because I want to discuss what happens if you can't get the third party to return a request form. So first of all, so this is in the context of you sending out a request. And we've all had experiences where we send it out and people don't return it. First of all, you have to keep trying to reach the provider, whether it's by fax, by phone, email, and you need to document your efforts on some type of a log. Because I want to emphasize that if you don't document your efforts, it didn't happen. And I don't know about you, but I have enough trouble remembering what I did today, let alone a year or two ago. And if you get investigated, you're not going to be able to honestly remember what you did a year ago or 2 years ago or 3 years ago. In addition, I want to emphasize the importance of picking up the phone and trying to reach an office as opposed to keep mailing it out. Because oftentimes it's easy for mail to get lost, and I'm sure everybody's heard this, the squeaky wheel, gets the oil. And so following up, and when we're talking about someone's civil rights, it's important to do as best a job as we possibly can. The other thing is to contact the applicant or the resident to inform the person of your efforts and ask for assistance, okay? That's very reasonable because, again, you're reassuring the resident or the applicant that you're trying to work on their behalf and you've been unable. You can also offer to have the person come to your office and try together or to conference the applicant or the resident into a call. Trying to be as flexible as you can. Or another alternative is to ask for another third party. But again, you need to document your efforts and you need to make every effort to respond to all requests. And this means staying on top of things and keeping the applicant and the resident informed. Based on my experience, people primarily get sued. Not always. I'm recognizing that some people are sue happy. And the purpose of this isn't to only talk about how to avoid getting sued, but what I am going to tell you is people file complaints when they feel like they're not being heard, when they feel like they're being mistreated. And so one of the things we want to emphasize, not only because it's a good business practice and you care about your applicants and your residents, but for your sake, is document all your efforts. So assuming you've done all that, so what happens next? Well, if the disability is obvious and the nexus is obvious or third party verifies that the disability that the person has a disability and or the nexus, you as the grantee or the owner have to make a determination regarding whether the requested accommodation poses a fundamental change to the program or poses an undue financial and administrative burden. Okay, so if you determine it's reasonable, then you need to approve the request. And by approving the request, you want to inform the person of your approval in writing, but not only in writing, but when the work, particularly if it's physical work, is going to take place. Because people want to be kept informed. And if there's going to be a legitimate delay, and there are oftentimes a lot of legitimate delays, either because appliances haven't come in, or parts are delayed, or it requires possibly digging up ground which is currently filled by snow or is frozen, etc. Inform people of the delays and when you expect it to happen. Again, keeping people informed and documenting your efforts is key. All right, so now let's talk about denying a request. This is a reminder. You can only deny the request if the person doesn't have a disability within the civil rights definition, or there's no nexus between the disability and the requested accommodation, or the request is either going to pose an undue financial and administrative burden or a fundamental change in the program. And if it's any one of those reasons, it's fine to deny. However, you must follow either your agency or your site's procedures. And typically this includes obtaining the approval of either a regional manager and or a 504 coordinator before denying a request. I'm a firm proponent, and again, this is my opinion, of having someone else review any denials to make sure, again, that you've dotted your I's and you've crossed your T's, and that the only reason you are denying is because either the person doesn't have a disability, there's no nexus between the disability and the requested accommodation, it poses a fundamental change in the program, or an undue financial and administrative burden. The key is also, if it's the latter two, in other words, fundamental change or an undue financial and administrative burden, what's the analysis? Is it written out? Can you document it? So very recently, there was a request made for a site for a bathtub for someone who had a physical disability, and the healthcare provider insisted the person needed a bathtub. And a response back from an owner was, it's not possible. And my response back was, who says that? I want evidence from an engineer and from the building system analysis saying it's not structurally possible. An individual who's not qualified to tell me that it's not possible, that's not evidence that I can use. It doesn't mean that the owner is incorrect, but I need something much more concrete than a conclusion or an assumption about what can physically be done to a unit or to a building, rather than just my assumption. Because I'm not an expert in building systems or a structural engineer. So I want to rely on people who are experts, because if it gets challenged, we have the documentation. And remember, we're in the business of providing accommodations to people with disabilities. Okay, so I want to talk about, in addition, next steps when an accommodation is determined unreasonable. First of all, your obligation doesn't end. You're required to do anything up to the limit of undue financial and administrative burden, or anything that won't pose a fundamental change in the program. There's language which says in HUD's guidance that you should engage in an interactive dialogue with the requester in terms of what's going to meet the person's disability-related needs, but not pose a fundamental change or an undue financial and administrative burden. I want to say a couple of things about this. First of all, I believe a 504 coordinator, someone who really understands this, can be very helpful in dialogues with applicants and residents. And again, depending on the rapport somebody has with their residents, this can be even more helpful than in other situations, or less helpful. But the other thing I want to mention is that even though HUD uses the term should, the failure to engage in an interactive dialogue can be considered discriminatory, because basically it's a denial. And in relation to my experience working with HUD's Fair Housing Office as well as state agencies that do enforcement, they insist on an interactive dialogue to show that you've actually explored all of the alternatives. And so from my perspective, it's a good business practice, and I also believe it is in accordance with not only the letter of the law, but certainly the spirit of the law to engage in that dialogue. And if an alternative accommodation would effectively meet the requested disability-related needs, and it's reasonable, you have to grant it. All right. So I also want to mention that if it's an undue financial and administrative burden, and you've established that, again, I'm circling back that you have to then explore if and when the work or a portion of the work can be done. Because again, you have to do everything up to the point. So if a roll-in shower is going to cost $6,000 and you have legitimately determined that that $6,000 is going to pose an undue financial and administrative burden on your site, and you have checked with the asset manager, et cetera, you need to figure out, well, what work could be done? And if not, the individual always retains the right to pay for the requested accommodation, or up to the point that makes it not an undue burden. Okay, so I want to now shift to concerns that housing providers commonly raise relating to reasonable accommodations and modifications. There are standardly 4, and I'm going to break these down. So they're bad precedent, not treating people the same as discriminatory, the number of requests, and the timing of the request. Okay, so let's take the first one. Providing an accommodation or modification is going to set a bad precedent and result in other residents wanting the same request. Yes, this may be true, but it can't be a denial or the basis for a denial. So I want to make sure, I don't know what happened to the slide, that's weird. I also want to talk now about the not treating people the same is discriminatory. So providing an accommodation or modification for a resident and not doing it for another resident who wants and needs it, or wants and doesn't need it, the notion is that it's going to be discriminatory or perceived as discriminatory. Okay, it's not illegal to deny a person an accommodation if they don't have a disability or don't need the accommodation because of a disability. Okay? Again, historically, we've all been told that if we treat everybody the same, we're not discriminating. The problem with that is that when we talk about people with disabilities, we're legally required to make reasonable accommodations. And the perception is, and it's really to equalize the playing field, to give people an equal opportunity to apply to or enjoy their housing. So when we deny an accommodation because someone doesn't have a disability or because they don't need the accommodation because of their disability, it's not discriminatory. In addition, you could also deny it if the accommodation would pose an undue financial and administrative burden. It would be difficult to establish that the accommodation poses a fundamental change if you've previously done it before. But it is very possible, based on budgets and timing, that if 10 people in your development ask for roll-in showers all at the same time, that you might be able to do it for the first 5 and not the next 5, in which case you would have to work with the latter 5 to figure out when you could do it, what you could do, and what you could do in the interim until you can put those roll-in showers in. Now, this is assuming that everybody has a disability and everybody needs those roll-in showers as a result of the disability. So I am the first one to acknowledge you're going to have to diffuse situations where residents believe you are acting out of favoritism. You're going to get, how come she gets this? I want that. And I want to remind everybody about privacy rules, confidentiality, and that you cannot share why someone is getting an accommodation. You can't say, well, she has a disability, or she is blank, blank, blank. The only answer you can say, and I use Mrs. Jones and Mrs. Smith all the time, Mrs. Jones, I'm really sorry, I'm not at liberty to discuss Mrs. Smith's situation with you. You wouldn't want me to talk about you with another resident. And that's pretty much all you can say. Okay, so the next concern that comes up is that there has to be a limited number of accommodations a resident can request. The reality is this is not baseball where you get 3 strikes and you're out. The law doesn't set a specific number. Regardless of how many requests you receive from someone, the same process must be followed. Okay, so then we're going to turn to the final one, which is the timing. A person with a disability should be required to let a provider know that they need an accommodation or modification at move-in. First of all, it's the applicant's or resident's choice when they make a request. Yes, this is a program that has an eligibility definition of disability. However, it doesn't mean that someone needs to make a request at move-in. Second of all, an applicant or resident doesn't waive their right to make a request because they didn't ask at application. So I really want you to think about this. And the third one is that I can make a request at any time during the application or during tenancy, and that includes even when I am facing eviction. Even if I haven't asked you for the request up until this point, and we are in court, and we're before the judge, and I or my lawyer says, hold up, we're requesting an accommodation, you got to consider it. It doesn't mean you have to provide it, it means you must consider it. Okay, so what I want to do now is I want to turn to the resources that are available, and then we're going to talk about some of the questions. But I first want to point out the resources. So what we've done today is it's a summary of the basics. And the reason we started with this rather than going into some of the more complicated scenarios, as I mentioned, such as negative tenancy-related history, lease violations, assistance animals, live-in aids, and screening for live-in aids, is because I think of this as very much like a pyramid. And if I don't know if you can remember when you were like playing those games where we all climbed on each other's backs, or many of us did, and if you didn't have a strong base, you crashed pretty damn quickly. And I consider like what we did today as the strong base. And so the next time when we get into those more complicated areas, we have the stability of referring back to the basics. And the basics that I covered today, and I'd encourage people to read them, are in the two joint statements that the HUD and DOJ put forth. I think they're very well written. They're in a question and answer format, and I think they lay out not only the obligations under the Fair Housing Act, but towards the back of it also discuss briefly Section 504. In addition, the HUD Handbook 4350.3, specifically Chapter 2, which is the first substantive chapter that HUD wrote. The first chapter is really an overview of the programs. The second chapter is really all the civil rights and non-discrimination requirements. And there's a subsection specifically on reasonable accommodation. I'd encourage you to read that. And it talks about HUD's position on things. In addition, Mass Housing has a handbook on the legal obligations and rights of public and assisted housing providers under federal and state fair housing laws for applicants and tenants with disabilities. And it was originally produced under a HUD Fair Housing Initiative Program grant. It's free of charge. I'd encourage you to pull it down. It actually goes through again in a question and answer format. A lot of the more complicated questions that we're going to talk about at the next training. In addition, there is a HUD website which has some very good information on it, not only reasonable accommodation under the Fair Housing Act, but commonly asked questions under 504. And again, the next training is going to be on Tuesday, March 13th at 2. We're going to talk next time, as I said to you before, we're going to cover the screening. Specifically, we're going to look at, do I have to lower my program's site suitability standards if someone has a disability? Do I have to let an applicant with a disability in to my program or site if the person has a negative tenancy history or criminal record? Do I have to let an applicant in if they currently illegally use a controlled substance? What if they use medical marijuana? We're going to look at assistance animals. I mean, not physically look at them, but I mean, look at the issues, which are pretty common. You know, do I have to permit assistance animals if I have a no pet policy? What does someone have to establish to obtain an assistance animal? Can I limit the size, the type, the breed of an assistance animal, and what can I require? And then finally, live-in aids. What does someone have to establish to get approval for a live-in aid? Can I screen live-in aids? If yes, what for? And finally, lease violations. What should I do if a resident with a disability violates the lease? And if a resident requests an accommodation to address a lease violation, does a housing provider have to consider the request? Okay, so now we're going to take questions.
Okay, we've got some really good questions that we got. That we got online. So we'll start with those, and then we'll open up to see if anybody has anything more. As we've discussed, Debbie, this program has grantees, mostly the state housing finance agencies or the state housing agencies, and then owners. And one listener asked, does the grantee need to have established reasonable accommodation policies in their role, and how do you think those might apply to the owners?
So the first part of the question is, do grantees need to have established reasonable accommodation policies? In my opinion, yes. How would you know what to do? How does the staff know what to do if you don't have them? And you as grantees have the right to explain to housing providers what the basic obligations are and making sure that housing providers are actually fulfilling their commitment around reasonable accommodation. So again, laying out what I would recommend, laying out parameters. I think you function as a team, and you want to function as a team, and the more that both the grantees and the housing providers are on the same page and everyone is working together and everybody understands that both parties are covered by the obligation to provide accommodation, have policies and procedures, what they are, what they look like, and how you're going to work together, I think that's most helpful.
Thank you. Do you have any thoughts about how grantees could potentially monitor property level compliance with reasonable accommodation?
I think that it's a great question, how grantees could monitor it. One possibility is, and again, it's the degree to which you want to take responsibility for this, because you have to ask yourself, what are you going to do if the housing provider is not following through? One thing you could do is ask to see the reasonable accommodation logs, just like when there are standard checks, or ask if people could send you a tracking sheet of what the types of requests are, because I also think it would be beneficial for you in terms of planning and assisting housing providers in meeting the needs, and you understanding what housing providers are facing. But it would be helpful to see what the requests are and what actions have being taken. That's the only, or the other thing you can also do is ask for a certification that people have been in compliance with the reasonable accommodation requirements. You could ask that people send you their policies and their forms, but I don't know what degree you want to actually be having oversight over them. I think that's, a question for you to ask internally in terms of where you want to draw your line. But I do think it's important, because it is your program effectively, for you to make sure that things are being done correctly, and that the obligation to provide people with disabilities reasonable accommodations is there. And one of the things I would recommend is, to what degree are people being notified of their rights of reasonable accommodation? Is it part of the process? At what part? Asking for it to be signed off by residents, that they're actually being informed of it, being provided a copy of a notice with a reasonable accommodation form, saying, and I would expand it to not only reasonable accommodation, but the obligation not to discriminate on the basis of any protected status, the obligation to provide reasonable accommodation, and the obligation to provide free language assistance to individuals with limited English proficiency. I think it's important for people to be on an ongoing basis, not only at application, but at research. And again, if I were a grantee, I'd want to make sure that my owners were, and when I say my owners, but people I'm contracting with, are actually informing people of their rights, and providing parameters of how best to do that, and certainly notices in plain language. And not only giving them the notice, but during the interviews, actually going over the forms with somebody. It's not just handing someone a notice and thinking they're going to understand what reasonable accommodation is, and setting aside the time to really explain it to someone.
Great, thank you very much. So switching gears a little bit, one of the listeners asked, some of the properties on their application say that somebody needs to have an income that's twice the rent in order to be eligible. So I would ask what the basis of that is if a unit is subsidized. So I think that the question is, that's even a broader question than it has to do with, it's a suitability question, but on what basis is that being stated when rent is based on a formula? Yeah. And so generally speaking, HUD has not permitted that when it's a program whereby rent is based on a formula. So I'd be curious to know, is it a general application? And it doesn't sound like it's an application or a screening criteria that should be being applied to people in the 811 program. Yeah. We also hear a lot about, and this is not a question, but credit checks.
Right. So
same kind of thing, right?
Well,
or
and
different?
The question becomes, it's slightly different, but it's on the same thing. Why do we screen? We screen for credit because of the ability to pay rent. So one of the questions is really, because that's really what we should be screening for. So really, there's some thinking that we should only screen for credit if people have a negative tenancy history based on payment of rent. So in other words, otherwise, why are you screening for credit? Because, or are you following me?
Yeah.
Okay, so then the question becomes, or no credit history at all. So you can reject for bad credit, but then what are you looking for? You're looking for, from my perspective, and this is where we can get into the disability piece, you're looking for the ability to pay rent. So how are their rent payments? What about utilities? Those are really the only two things. Whether or not I paid my medical bills, which I may have very large ones, why is that relevant to housing? And so one of the things, and we are getting a little off track, but I think it's important for housing providers who are on the call is to understand is, what are the screening criteria trying to get at, and making sure that they're not discriminatory, not only intentionally, but have a disparate impact on people with disabilities.
Great. Catching up with the questions here. If a person has a live-in aid that is agency-based, not a family member, is there reasonable accommodation so the agency's employer doesn't have to go through the same application process? It's with rotating live-in caretakers.
Oh, you mean in terms of screening?
Yeah.
Okay, so unfortunately, or fortunately, depending on how you look at it, if you're the housing provider, HUD has required live-in aides as opposed to PCAs. So personal care attendants who may be assisting in daily living functions but are not living there do not need to be screened. But anyone who is a live-in aide must, it's not a should, it must be screened for suitability. And when I say suitability, I really mean criminal and landlord history, not credit, because they don't pay rent. And there's other types of screening that are going to have to be done as well. For example, the existing tenant search, social security numbers, there's certain criteria that HUD has insisted on a live-in aid. So I don't see a way, quote unquote, around that, unless the person were to make them not a live-in aid, but a PCA.
Okay. Yeah. Rotating caregiver.
Right, but then they wouldn't be eligible for sometimes needing the second bedroom.
That's possible, but it's also possible that HUD or the owner, you could establish that they need it because the person, exactly, or for other reasons. I mean, there may be a way to do that, but I mean, the question is, how often are they turning over? I mean, that would really concern me.
So they could technically,
Yep.
so they could technically, the live-in aid could technically be screened more heavily or more than because of HUD's criteria than the person was originally screened.
You mean screened by the agency that hired them?
No, the landlord.
No,
Oh.
the landlord is the one who uses HUD's criteria
Right.
to screen the live-in aid. The same standards are used for an applicant to housing and for a live-in aid, with the exception of credit.
Okay. So if a landlord didn't screen the applicant at all for criminal background, and then because HUD says, do they have to screen the live-in aid for criminal background?
Well, you're supposed to use this at minimum the same standards, but they have to screen for certain things with criminal background. So they're required to screen, for example, for a lifetime sex offender registration requirement. That's really the biggest
So it's the
thing.
same that HUD makes them
That,
screen for.
yes,
Like
that you have to screen. And HUD has also said you must establish policies in which you are limiting people who have a history of certain types of actions or behavior. And we're going to cover this in the next training. But it's great questions.
So there's a question here, I think that's basically, if somebody's been terminated from a program, they're terminated. They use the word terminated, not evicted, but let's say in either case, can they request an accommodation after the fact? What if they didn't understand they had the right to an accommodation that might have prevented an eviction?
I think if you've got an eviction, so we'll take the eviction, they'd have to go back into court, and I've never seen it just reverse an eviction if it's already happened. And unfortunately, it's a sad reality. Some people don't know what their rights are. In terms of a program, a social service program, I mean, I think it's really going to be up to.
Or in some specific circumstances, there's questions about whether or not someone would ever be terminated from the 811 program itself, whether that's
I mean, I think it's a question of if they truly did not understand. I always err on the side of the resident or the program participant, and because we're in the business of housing people, right? That's really the way I look at it. And I also always look at my goal. What's my goal? Well, my goal is to house people, and our goal, particularly for this program, is we're trying to serve people who need a specific type of a program, right? I mean, isn't that the goal? And so is it possible that someone didn't understand it? Yes. So why wouldn't I let them reconsider? What were the circumstances in which they didn't understand something, and what's changed? You know, what's changed for the person? Is it they didn't understand it, or was it, are they going to be able to comply with whatever the rules are? But this is the thing. This is why sometimes I encourage people to actually, around lease violations, sometimes get into court, not with the goal of evicting, but with the goal of having the person obtain the services that they need in order to comply with the terms of the lease. And to be able to then, through the courts, come up with a solution. Although I don't generally like to involve the courts, sometimes you have to.
Okay, a few more questions.
Sure.
So one of the states indicates that they get a lot of requests for additional bedrooms for single parents in order to reduce clutter and anxiety after the birth of a child. The single parent has a serious mental illness, and they are asking for an accommodation to reduce their anxiety and possible symptomology. Would you say that's reasonable?
Okay, what I would say is it's an individualized assessment, and I would need to have documentation from the healthcare provider. The question becomes, what's the nexus? How does the extra bedroom connect to the anxiety? And I'm not this individual's healthcare provider, so I can't answer it. What I've also seen, though, is, so I would have the healthcare provider explain the nexus and establish it and explain it. It's not for me to judge whether it is, whether the nexus exists. I'm not a mental health professional. Where I draw the line is when it becomes the extra bedroom to reduce my anxiety because I have so much stuff and I'm really hoarding my stuff. And I need now not only the second bedroom, I need the third bedroom because I've got so much stuff and it's anxiety. That's a lease violation. And so the question becomes, now I'm switching it, but I think there comes sometimes as a balance. But I think what this person is also raising is that sometimes there is a use of a request for an accommodation to get something that, or appears to get something that they wouldn't otherwise have, and it's not necessarily warranted. But I'm not the person to make that judgment. The healthcare provider is.
Yep. So a couple more, and then I think. So some of the Deb, some of the grantees have sources of funds to pay for example, modifications. Some of the grantees have money follows a person programs that are moving people out of nursing facilities, and they use some of their admin, for example, for those purposes. So how do you feel like that fits in?
Well, I think that's great. I mean, that's fabulous to hear. I mean, that's the situation. I think it's amazing. That's great to hear. I don't want any of the owners, though, to think that they're off the hook because the grantees have this money. The owner's obligation is the owner's obligation. And again, when they do that analysis of an undue financial and administrative burden, it's great to know that that's a resource. If that's the resource, then the likelihood of it ever hitting an undue financial and administrative burden is virtually nil, assuming, although there's a pool of money. The other thing I would say is, and this is a dialogue that the grantee would need to have with the housing provider, is, very few housing providers have unlimited pockets. And so there's nothing wrong with the grantee and the housing provider agreeing that they could first go to the grantee if that were the case, but that's not, I wouldn't want any housing provider and then leaving money for the other residents who may need physical modifications. But if that were established, I would never want an owner to think that they're off the hook, and that if the money runs out or if the grantee chose to not do that, that there would be any animosity, because the obligation is the housing providers as well.
Good point.
That's great.
How about a couple more things and then we'll wrap up? We started a little late. We're going a little late.
I don't care.
I think we still have a fair number of people on. So one of the states actually I've been doing some work with has talked a lot about working with people with serious mental illness who will not sign forms because of their kind of paranoia. They won't sign the recert form. They might not sign their lease. What do you think?
Right. So this becomes a fundamental change in the program. People have to be willing to, it's a requirement that they recertify and that they sign a lease. So one question I have is, what about a power of attorney? Would they be willing to establish that someone has the authority to then be signing on their behalf? It doesn't give them guardianship, it simply gives them power of attorney. It may be a way to meet the needs of the resident.
Compromise.
It's a compromise, and it's perfectly legal. And then the resident is not bothered, and management gets to meet their needs. But to not do anything is a fundamental change.
And I don't know if this is a question for next time, you tell me, but we'd be interested to hear you weigh in on whether you think it's a good idea or not for an applicant who knows that they have some difficult history of some sort, tenancy related, whether when you apply, to proactively write a letter laying out sort of, I got evicted 3 times, I was using drugs, but I'm sober now, and
Right.
I have these supports. Is that a good idea, or should you wait through and work through this process after the application is in?
I think I can talk a little bit about it now, and then people can follow up for next time and send in more questions, because I think that this could be a real dialogue. I think the question becomes, what's the likelihood, the first question, if I'm the applicant, what's the likelihood the housing provider is going to find out about the history? So is it going to show up on a criminal background check? How long ago was I in jail? How long ago, how many landlords back was my negative tenancy history? Because that's the first starting point. If it's not going to come up, or unlikely, don't raise it. If you really believe it's likely to come up, and one thing I would do is I would pull the tenant selection plans of any of the housing providers and they're public documents, so everybody should be.
In this program, actually, the grantee reviews the
TSPs.
Yeah.
So what I would recommend is, as people are applying, comparing the likelihood that this would come up. If it's likely to come up, I think it's a good idea, because I would rather know and I'd rather have considered what's changed. But if I don't need to know your history, don't tell me. Because the way I look at it is we all make assumptions. We're not supposed to make assumptions, but we make assumptions. It's kind of like, well, it's not, I'm aging myself, but there's this book or a series of children's books, the Bernstein Bear books.
Oh, yeah.
Everybody knows those. Okay, so the books, you're still reading them? Yeah, on my
I have a
Kindle.
3-year-old.
So, perfect. So, for those of you who are unfamiliar, it's a story centers around a bear family. The mother, the father, the sister, the brother, and I think there's a baby cub now. But anyways, each book has a message. And there's a book about strangers. And the mother cub is trying to explain to the baby cub, the daughter cub, that she, you can't judge a book by its cover. And so to illustrate the point, she takes out the bushel of apples and she pulls 2 apples and visualize in your mind whatever you think is that perfect looking apple, right? And then she takes one out that looks like the one that would sit certainly in my fruit drawer forever because no one would throw it out. And I have actually tested how long it would take somebody and it doesn't happen. So it's the one that no one would want to eat. And she cuts the apples open and the one that looked disgusting on the outside is perfect inside, and the one that looked perfect on the outside has worms. So what's the point of it? The point of it is the outside of the apple I think of as all the different protected classes. Race, color, religion, sex, national origin, familial status, disability, which is what we're talking about today, but actual or perceived gender identity and sexual orientation and legal source of income and etc. The cutting of the apple open is your tenant screening. It's your tenant screening. And unfortunately, people make assumptions about the outside. And the minute you start talking about certain things, and it could be, I was in jail for this, or I was a drug addict, or the images come up. But really, when you think about the tenant screening, it's the criminal. If you're talking about credit, it's the engaging in the dialogue with the person about what's changed in their life. That's really it.
That's a great note to end on for part 1 of this 2-part series. I think you've just whetted our appetites to get into some of these what are complicated gray areas. It's not
easy.
Not easy, and I think you will. Everybody who's participating today or registered and didn't participate will get a copy of the slides from today, as well as a registration link for the next one on the 13th at 2 o'clock Eastern Time, again with Debbie Pilch. If this discussion has made you think about some questions, please send them into your TA lead or Lisa, me, or Liz, anyone. Feel free. Ellen Fitzgerald's a perfect person to send them into. And we'll use those next time. Sorry we didn't get to the hand raising part. Please, bring this. This is being recorded. It will be uploaded as a 508 compliant webinar on HUD Exchange, so you can share it with your owners, for example, and start your own discussion locally. We look forward to talking to you again on the 13th. Thank you.
Thank you.
So what's weird is, are we off? No, this is Lisa's, right?
Yeah.
This one
And
here.
webinar. Yep.
Mm-hmm.
But the voice is off.
Mm-hmm.
The phone